Devin Lucas here to talk to you about real estate mediations and compliance with the California Association of Realtors Residential Purchase Agreement. We're going to try to break down a lot of information in a very short video, including what is a mediation, what is the requirement for mediation, who should attend the mediation, should you get an attorney, where to find a mediator and what are the costs, attending the mediation, how does it work, how to comply with that requirement in the purchase agreement, and one of my favorites, what happens if the other party does not comply or is being overly difficult. Let's get into it. Mediation, what is it? A mediation, by definition, is a meeting with a neutral third party to help facilitate a dispute resolution. Let's break down what that means. It is voluntary in that parties cannot be forced into mediation. However, within your contract, specifically the California Association of Realtors Purchase Agreement and many other modern contracts, it requires you to mediate first before you can file a lawsuit. How does it do that? Well, it punishes you essentially if you jump the gun and just immediately file a lawsuit. What do I mean by punish? Within all of these contracts, there's typically a prevailing party attorney's fees. What that generally means is that if you have to spend $100,000 in a lawsuit to prove that you are right and you win, in theory, the court is also now going to award you that $100,000 in attorney's fees on top of whatever your other award would have been. It's a very powerful tool, becomes both a sword and a shield, and in my opinion, people dig themselves in the hole wanting to get those fees, but that's a separate issue. Bottom line, if you don't go to mediation first, if you jump the gun and just file a lawsuit, then you're in trouble and you're never going to get those attorney's fees even if you win. Let me repeat that. Let's say you spend $100,000 to win a case and you win. You'll win whatever you're going to win. But that $100,000 that you just spent, you are never going to get that back because you failed to mediate a case. It's a very expensive mistake. Attorneys get themselves into trouble by just filing lawsuits without reading the contracts. Parties certainly get themselves into trouble for that exact same reason. So, of course, read your contract. If it has a requirement for mediation, you should comply. Who is the mediator? Well, the mediator can be anyone, really. There's no special license or requirement for it. Typically, you're going to want some sort of expert in their field, an attorney with a background in the real estate matter. If it's a real estate dispute, that's what I do. But, cases can be about anything. So you're going to typically want someone with experience. It doesn't have to be an attorney. It doesn't have to be a retired judge, but those are the most common people that are used in mediations. Where do you find a mediator? You can find them anywhere. Google it. When it comes to real estate, and with the California Association of Realtors has a specific mediation center for consumers. It has a list, a panel, if you will, of mediators. I'm on that particular list, as are many other great mediators, and you can choose. We've all agreed to essentially do it for free. Not really, there is a cost involved, but it is a dramatic reduction from what a lot of those parties would normally charge as far as their hourly rates and whatnot. And especially if you try to go to some of the bigger companies, and they're great, they can be great at resolving very big disputes, but if you've got a $10,000 or even a $100,000 dispute, you probably don't want to go spend $20,000 on a mediation. You probably want to look for something that's more along the lines of $1,000. Each party split it, so you're looking at a few $100s per party. So it's very easy. Google it or check with the California Association of Realtors. They will help you get in touch. Who should attend the mediation? Well, you're going to have to look at your contract. This gets a little tricky. In a typical buyer and seller dispute, people often want to bring in other people as well, such as brokers, brokerages. Maybe there was a flipper involved, so maybe they had a contractor. Maybe people are mad their home inspector didn't find out about something. Whatever it is, unfortunately, you're going to have to look at your contracts. Typically, when there's a buyer and a seller dispute, they have a purchase agreement amongst themselves, but other people such as contractors, realtors, brokers, other that might be involved they might not have a contractual relationship with whoever is bringing the actual lawsuit. I'm drawing these invisible lines in law school. We learned it. It's called whether you're in privity of contract with someone. And I don't have a whiteboard here, but when I do this presentation, I show a fancy little connection. You have to have a contractual obligation with someone to go to mediation. That's the requirement, right? Because otherwise you lose their attorney's fees or whatever the contract is. If you don't have a contract with someone, they don't have to attend mediation. They can tell you to take a hike. And that unfortunately does become a problem in some of these cases where, maybe the buyer and the seller agree because they have that contractual obligation, but there might be many other parties that they're looking to in the potential lawsuit, and you're not able to get them to the mediation. So I don't have a magical answer for you there. All I can tell you is that when you look at the purchase agreement, the buyer and the seller have to mediate. So don't make the mistake of saying, well, I'm not going to mediate unless everyone else mediates, because that's just going to get you in trouble. You still have to do it. So look at the contracts. That said, even if they don't have to, sometimes other people do show up. Sometimes the brokerages will show up or things like that. I have a real big caveat there. You got to be careful, especially to agents, and this might be a message to you agents out there. You might think you're doing yourself or your client a service by helping them out with the process, maybe even attending the mediation process, but you're really causing a lot of problems. First of all, you're probably practicing law without a license, and you shouldn't be doing that. Your client probably needs an attorney, not you, or at least to talk to one. Second of all, you as the agent of the brokerage might be a target. So if someone is suing over a fraud or a non-disclosure issue, the reality is they're probably going to sue agents as well. So while it's all well and good that agents want to show up and help guide their clients or be a helping hand, this is a legal process, and it can be very problematic if you don't really understand the role that you might be in. So agents, take note, maybe certainly talk to your brokers about it before you show up at a mediation. I have literally had realtors walk out of mediations because they call their broker. The broker says, "What the heck are you doing there? Leave," and they leave. And vice versa. I've had people that say, "Oh, I wish I could have attended the mediation, but they didn't know about it." So, you really got to try to get everyone involved, but ultimately the only people you can force to go are the ones that have that contract. Is an attorney required for the mediation? That's up to you. To be perfectly honest, attorneys are big pros and cons. Obviously, if you have a huge dispute, if you've been wronged, you may eventually need an attorney. At the other end of that spectrum, to be honest, attorneys cost money. And once everyone starts hiring an attorney and starts spending money on attorneys, that further ingrains people sometimes into the position. So whether or not you need an attorney is obviously a difficult decision that everyone's going to have to make. Certainly some people don't even have that option because there's a cost involved there. So you're going to have to find out if that's right for you. Certainly you might want to talk to an attorney. Some attorneys do consultations. Maybe you have to pay for that, but it might certainly be a good thing to do before just walking in blind to a mediation. That said, honestly though, some of the cases that settle most frequently are cases where parties don't have attorneys. And I think that's because they do tend to be smaller disputes that people want to work out anyway. But it is ironic, sometimes that does happen. So you'll have to decide if you need an attorney or not. Attending the mediation. So let's talk about this. I have another video you can watch on the virtual mediation process, but whether you attend in person or virtually, it's a very similar process. Now, some mediators use a collaborative approach where they like to put everyone together in the same room first and have people talk it out. Some mediators, including myself, take a different approach where they separate the parties to begin with and probably throughout the whole thing. In my experience, people really don't want to see each other. They're already mad at each other. There's already bad blood involved. So I personally just don't think it's appropriate to force the parties into the same room together. And certainly now virtually, people are already uncomfortable about being on camera or being in their living room. So I'm certainly not going to, thrust you in front of someone that you don't want to be in front of. So, but either way you do it, talk to your mediator about the approach they take. Typically, there's either some sort of beginning session where you're all together, or the mediator simply does two of them. So there'll usually be some sort of introduction, how are you doing, go over the process, talk about the person's credentials, talk about the agenda of the day. They'll logistically show you where the restrooms are, or if you're doing a virtual one, maybe there's some technical things to go over first, but you'll basically get situated. And then eventually you'll start talking about the case. You'll start talking about the dispute, what you feel the other side did wrong, or what you feel you didn't do wrong. Whatever it is, there's definitely a lot of emotion involved in some of these cases, so people are going to want to air out their grievances. And then at some point in time, you're going to start talking about settlement. Usually that is money, but not always. Sometimes a specific performance case, for example, where people are suing over the actual right to buy the property, then sometimes the settlement is potentially actually going forward with the sale. But most often it does come down to money. And typically whoever brought the case initially is the person that's going to make a demand. So they're going to ask for, hey, I want $100,000 or $10,000 or whatever it is. They're going to make that ask. And then typically the other side is going to potentially counter that. Sometimes they don't. Sometimes literally people are not in a position to settle, or they come for the wrong reasons and there is no dialogue to be had. But more often than not, you'll usually start engaging in a dialogue about the settlement and eventually, hopefully, come together and make a deal. Now, there's plenty of books, there's lots of videos, there's hour-long content, there's presentations that I do on the topic of, how does that actually happen, way too advanced for this video, but, just two basic things to keep in mind. Some mediators use a facilitative method where they're really just facilitating a dialogue. What can I do for you? What would you like to do? How do you think that makes the other person feel? What would you like to see as a resolution? More of a facilitating. And then some mediators use an evaluative approach, which is typically found with a lot of retired judges and stuff like that, where you want their opinion. So the judge is going to say, oh, I've seen this. And keep in mind, they're probably going to, try to argue with both sides, but they're going to go to each side and say, I've seen this, and, these cases rarely win, and, you could lose, and you have problems with X, Y, and Z, or they're going to tell you how great your case is or something. Bottom line is that some mediators are going to be more comfortable than others about actually giving you sort of a legal opinion or a thought on how that might actually pan out in court. A lot of mediators are just going to try to facilitate. They don't really want to give an opinion. I personally do a little bit of both, and it certainly depends on the case, it depends on the parties, it depends on what they want to hear from me. But given that I have done it, I've been in trial, I've been in appeals, I find that usually that's why people are coming to me. They want my experience, and so I do think it's appropriate to share that a little bit. I've had a few cases, to be honest, where it's very clear what's going on, and I usually will kind of tell people my thoughts and opinions on the case. So that's what I do, and that's typically how it goes. So that's really it. That's kind of my short video on what to do as far as the mediation. Oh, what if the other side doesn't agree, and how do you schedule? We completely skipped over that. This in and of itself is a whole separate topic, but look at it this way, and I have a sample letter in my blog that I've done on it. Attorneys certainly have letters. You can get a sample letter from your realtor. There is one in the software there. You have to basically send the other side a demand for mediation. Demand it. Say, hey, I want to attend mediation. Here's a list of agreeable mediators that we would use, and we want to attend mediation sometime next week or next month, something like that. You got to be reasonable. You got to give them a couple weeks to respond. Now, if the other side doesn't respond, you really kind of need to try. I certainly don't think it's good enough just to send a letter, and if they don't respond 3 days later, file a lawsuit. That's clearly not the spirit of what this process is about. So if I was you and I didn't hear from the other side, I would make sure to have multiple letters in my file before filing a lawsuit. I'd certainly try to maybe send one or more certified, something like that. Ultimately, at the end of the day, you could have someone personally served with a letter. You could hire private investigators to find where people live. There's some due diligence that you can and frankly should do before filing the lawsuit. On the other hand, what I think is much more common and frequent is where people are being difficult. They write back and they say, oh yeah, let's do mediation, but I'm busy for the next 3 months, or my client's out of the country, or because of COVID-19, I'll only do in-person mediation, so we're going to have to wait 6 months. These are more of the gray areas and sort of the common sense issues that are going to dictate. Right now with COVID-19, that's a whole different issue. I have a video on virtual mediations. I personally think people are going to need to do that. Courts have already come out with some guidance saying you need to move forward with video depositions and things like that. So I think when it ultimately hits the fan, I don't think the courts are going to look too kindly on people that are delaying the process because of COVID-19. So I think the court is going to want you to move forward, even if that means a virtual mediation. So I think you should definitely keep that in mind. And, you got to try to work it out. Sometimes if they say they don't agree on the mediator, well, you have to propose a different mediator or go to a company like the California Association of Realtors that has a panel and they can provide multiple options for mediators. They can even pick one if the parties don't agree. So, there's lots of kind of common sense things that you can do to try to get the ball rolling. But ultimately, I got to say, sometimes people just delay the process, or there is just legitimate scheduling issues. You're just going to have to work it out. If it takes a few weeks, or to be honest, even a few months to figure out everyone's schedule, that sometimes is the reality. But you'll know, and judges know too. Keep in mind, none of this matters unless you ultimately go to court and you win, and then you're trying to collect those attorney's fees. That's when you bring the attorney's fees motion. It's after the trial is done. So ultimately, if you prevail in the case, or for whatever reason you're the one bringing or arguing an attorney's fees motion, then you're going to bring all this stuff up. Hey, they weren't reasonable, they delayed the mediation, things like that. And judges know, if you have 20 emails trying to schedule a mediation and the other side just keeps blowing you off or comes up with lame excuses, eventually that's going to be before the judge, and judges usually are pretty smart about that. So I'd say common sense kind of rules the day as far as whether or not the other side is difficult. And certainly if you have an attorney, you're going to have to talk to your attorney. And those of you that are attorneys watching this video, I would just use a lot of caution. I've done longer MCLEs. There's published and unpublished opinions you can look up. But you really got to make a reasonable effort before you just jump right in. Now, there are exceptions. Read your contract. There's exceptions for bankruptcy, for filing and lis pendens, certain things like that where you are allowed just to file a lawsuit, but you certainly shouldn't be prosecuting it then. You can file the lawsuit to file your lis pendens if that's what you need to do, but you should basically be stopping at that point in time and then trying to go forward with the mediation process. So that's it. Trying to make a quick video. Please call us if you have any other questions. We do this a lot. We love doing this. We love trying to get people to settle cases. That's why I quit doing litigation for the most part, because I'd rather help people resolve the case or do other things on the front end. So best of luck to you all, and please let us know if we can help. Reach out anytime. Thank you.